Hello and welcome to Unpacking Contract Law, the UK-based contract law podcast delivering unsolicited opinions on new and old contract law cases. The purpose of these podcasts is to provide you with an insight into our thoughts, ideas and ideologies around all things contract law. It also provides us with an outlet for all our opinions, so you listen at your own peril. Each podcast will feature a new contract law case with a discussion from 3 contract law enthusiasts. And it is thus my great pleasure to introduce you to Maggie Hemsworth, Séverine Saintier, and myself, Tim Dodsworth. Welcome to Unpacking Contract Law. Well, how wonderful. Here we are then with our very first episode on our very first podcast covering the case of Braganza. Do we agree roughly with the description of the podcast?
Yeah. Try and work in some argument, shall we?
We'll keep the arguments for later on. Right.
Lively debate. Lively debate is the better word.
Lively debate. That's it. We need to change that. I'll have to add that in somewhere to the description of this in the written description. This is not an argument. It is a debate about various contract law cases, old and new. We'll try and bring one out every 2 weeks.
And contrary to
I've made a promise now.
Contrary to the presidential debate in the States, you can't mute us.
That is very true. There's no muting, so everything is real, and we'll try not to edit as well. I have the beautiful task of introducing the facts of the case, and Séverine and Maggie, you'll jump in when I get it wrong or miss things out. The basics of the case are we're talking about Mr. Braganza in a contract with BP Shipping Ltd, and there was a death in benefit clause in the contract. So you can tell from that already, Mr. Braganza, of course, unfortunately died in this case. He went overboard, and we don't quite know what happened to him. And we'll probably not spend much time on trying to work out what happened to him either. But we know from the facts that Mr. Braganza had money problems. He'd moved to Toronto in 2008 with his family, and it sounds like there were some various problems that arose with that. He had quite a big job on the vessel that he was on, and the vessel was in the mid-Atlantic. His idea, the whole point of the exercise was that he was supposed to lower some cooling jackets into the engine room, which took quite a long time, and it meant that the engines had to be stopped for that period of time. And of course, if you're going to stop the engines, then you need some good weather. And this whole good weather thing is partly what's so important. Mr. Braganza was seen last just after midnight, and they couldn't find him, so concluded that he had gone missing. The question was whether there had been a suicide or whether this was actually deliberate. Whether this was an accident or whether it was, oh my goodness me, that was a whoops. And the term of the contract was, as follows. For the avoidance of doubt, compensation for death, accidental injury or illness shall not be payable if, in the opinion of the company, and that's the important part, in the opinion of the company or its insurers, the death, accidental injury or illness resulted from, amongst other things, the officer's willful act, default or misconduct, whether at sea or ashore.
And if I'm going to jump in now, if you're inviting jumpings in, notice in that wording there is the absence of reasonable. It doesn't say in the reasonable opinion of the company or its insurers. That has turned out to be a big point.
Absolutely, I entirely agree. And with that, actually, in order to... BP then set up its own inquiry. The main purpose of that inquiry, and that becomes quite important actually, is that they were trying to work out whether their own procedures needed to be changed. That was the main purpose of that original inquiry. And later on then, this same inquiry, the result of that inquiry, which was that it was a suicide, was used as a basis of deciding that there should be no compensation.
That it was more likely to be a suicide. They didn't really know, but on the facts, they decided that it was, likely to be a suicide.
And I suppose that doesn't really matter, doesn't it? Because it's worth remembering this is all civil, and therefore everything would be judged on the balance of probabilities, more likely than not, every decision that you're making.
That's good, yeah. And the argument then was that, and this is where I can hand straight over to Maggie, really. The argument was that if they're going to use their discretion, they have to do so reasonably, and the question was as to the standard of that. And I think, Maggie, I'll just hand over to you to look at the judgment of Lady Hale in this case.
Okay. Lady Hale did speak for the majority, and what's interesting, I think, is the analogy that is being drawn between tests that you would naturally apply in the public sector across into something that is entirely private, because remember, contract law is an entirely private thing in a sense between two parties, in this case poor Mr. Braganza and his employers. But she's using concepts from public law, from the standard applied to public institutions, bodies making decisions, and she's applying it across. So effectively, there are now what looks to be two hurdles that have to be got over, and they're not very high hurdles. So if I just briefly explain what those hurdles are, you might appreciate how easy this ought to be for 99% of the time. So the two hurdles, the first one is just to check that the decision maker, who we are assuming is not a lawyer, but is exercising a discretionary power, and that's probably quite important to look at the wording of this particular clause, and that's what they're doing. The decision maker wasn't a lawyer, but he was exercising a discretionary judgment, if you like, on facts. He is going to be tested against the matters that ought reasonably to be taken into account when making that sort of decision, and to make sure that they are not taking into account irrelevant things. So it's what's called the four corners. In other words, you look to see what should be relevant for that type of question, for that type of decision making, and make sure you're within the perimeter of that. So leaving out of account the irrelevant, but obviously taking into account the relevant. And that's the first hurdle. And when you articulate it in that way, it ought not be too troublesome, I think. And then the second hurdle is to just double check that the conclusion itself, so now you're looking at not the process so much, but the end result. The end result is not so irrational or perverse, you might say, that it's not possible for any reasonable person to have come to that conclusion. So that's a very low standard too, because it is not the test of reasonableness, it's the test of perversity or irrational. Looks like it's done on a whim without any factual base at all. And if you get over those two little hurdles, then there's just a final sort of double check, this causational requirement, as it's sometimes referred to. That is just to stand back from that process and that decision and ask yourself, well, had they done it properly, in other words, had they got over these two little hurdles sensibly, would the decision have been any different? Because there's no point in upsetting a decision if the end result would have been the same had you done it properly. So actually, Lady Hale is setting, by analogy from the public sector, as I've said, but a very low threshold. Most people ought to be able to get over those hurdles without any difficulty. So you might sort of see this as perhaps making a mountain out of a molehill.
Can I?
Well, You've got something to say about that.
Yeah. So when Maggie, you say these are small hurdles. So
Yes.
you did I don't know whether I would put it.
Well, small in the sense of undemanding, unchallenging. It ought not be difficult for any rational person to be able to get over these hurdles.
Okay, but they are nevertheless important because so you did the one thing which is important to remember in this case is so you have mentioned the that it is applied in a public sector. So here there was a lot of discussion, when this case was reported as to whether this is giving too much discretion to the judges in relation to, as you said, Maggie, the fact that it is a purely private arrangement. So again, Lady Hell herself said that, when there is a contractual discretion, it is quite common. But whether then the courts have the power to effectively rewrite. So this is not what they are saying, but this is nevertheless the court interfering within the party's business and whether that is right or not. So when you say too small hurdle, it almost belittles what they did, and that's where I would like to slightly disagree with you. It is important that the courts here have the power to ensure that procedurally as well as substantively, when a party has discretion to make a unilateral decision which is going to have an impact onto the other party, when there is a conflict of interest. Here we mustn't forget that this is an employment contract, and of course the decision here to decide that it was a suicide meant that the widow of Mr. Braganza was not entitled to the death in service benefit, and so therefore there is a big it is crucial for Mrs. Braganza that actually here she was successful because the Supreme Court said yes, she's entitled to it. So these small hurdles, they are within the reasonable person. So I agree with you in the sense that this is an objective assessment, but this is still nevertheless a big thing that the court is doing. The court is checking whether substantively as well as procedurally, when a party has a discretion, that they use that discretion according to the terms of the contract. So in that sense, it is quite an important thing. When you say a small hurdle, it is not incompatible with the manner in which the courts objectively, when they interpret a contract, they will do it objectively. But I don't want to you all listeners to think that we are belittling the decision. It is nevertheless an important, because it is applying a public sector notion into a private one.
Okay, let me try and persuade you a little bit more then, Séverine. It is definitely not the court interfering with somebody else's contract. And the technique is a classic one, and is actually found current flavour of the week, as it were, with most courts. It's approached on the basis of construction. So it's looking at the party's own deal. We're not messing with it. We're not altering it. We are simply saying it was naturally implicit in that deal. Both parties would have assumed, without saying, so the language of implied term, it was bloody obvious, if you like, to the parties at the time that any decision maker would have kept themselves to the relevant and ignored the irrelevant, and would not have decided on whim or perversity, don't like the colour of your hair or your eyes, for example. But it's still quite a low threshold. It's still quite a unchallenging hurdle to get over. And if you think about it, simply that's reflecting the fact that it is an implied term. Implied terms, as a matter of fact.
On that one, if we're saying it's implied,
Yes.
Does a standard then change? So, Séverine, you mentioned in yours that it makes a big difference here that this is an employment contract. I mean, are we talking about a term implied in law? In other words, that they're going to say for each employment contract?
Lady Hale's talking about fact. So she actually goes out of her way, I think, to say at one point, this might vary from contract to contract. You might label this particular contract one of these relational ones, but all that means is there is a close ongoing relationship, and between employer and employee there is one of trust and confidence. But we have other branches of contract law where there is something similar going on, and when I don't mean to belittle the decision itself, but what I'm saying is the threshold that comes out of the decision is not a demanding one. I'm not saying that the decision is not important, but it's not actually making a lot of new law. If you look in the insurance setting, which is the area that I'm probably more interested in than employment currently, we've had cases like this before that have found effectively the same thing between insurer and insured. And Lady Hale does actually refer and draw strength from those insurance cases. There's Sockimer, for example, if you want to look at the case report, which is an insurance one. So an insurance lawyer possibly looking at Braganza would say, well, what's the big deal here? This is nothing new under the sun. We have had this for some time. It's just that it is now Supreme Court who have put, the top seal on this, as it were, and therefore it's going to be heavily influential. I don't belittle that at all. But in terms of new law, not a big deal. In terms of requirement and onerous nature burdens on a contracting party, not a big deal. You just have to be careful that your process looks sensible, rational. You are sifting the relevant from the irrelevant, and then I don't think you've got much of a problem in real life. So are we far apart? I don't know.
I just wanted to clarify when you said, we are in complete agreement. The standard indeed, so the Sockimer case that you mentioned. So yes, I think it's important that now the Supreme Court has expressly followed the Sockimer case, which indeed was quite a few years ago already. So I agree with you. I just wanted to clarify that we were not... because indeed the standard objective, you are absolutely right, it is nothing that we do not hear already the courts doing on the contractual interpretation. They do not want to rewrite, they are not telling the parties if there is anything missing that, etc., etc. But here, the fact that it is an implied term, that therefore substantively and procedurally it is nice for the other party who is being subjected to the contractual discretion, that therefore there is just another layer to make sure that the court can have the power to just ensure that the other party has followed the contract term, and if they haven't, then there is a possibility for that for the decision to be taken over, as was the case here. So yes, it's not. It has not created new law in as such, because it is already applying. In a way, it makes the law more consistent, and by the fact that the Supreme Court has given the seal of approval to the Sockimer case, I think is incredibly important. But nevertheless, the power, the power of the court to interfere can be seen in the party's business, can be seen as controversial by some, but it's not.
Well, you see, that's the point of dispute between us, I think. I don't see this as interference at all. This is merely making clear, explicit, what is implicitly part of the deal, and that's the whole thing with implied terms as a matter of fact. We're not writing stuff into the contract. We are saying, with a magnifying glass, if you look very carefully, it is already there.
But I'm really not sure. I mean, this reminds me very much of the old-fashioned, that we now agree isn't there anymore, basis for frustration, that it was just simply an implied term. that the parties obviously had thought. I don't think the parties really put their mind to this at all. And actually, if we look at BP, they probably thought, well, actually, we want a term in there that we can decide whatever we want on the bait. That's why we say in our opinion. And actually, we want to be able to make the decision based on essentially our financial interests. And I get the feeling Mr. Braganza didn't put his mind to it at all.
They might have thought that whoever was drafting it might have thought they had secured an absolute right by omitting that word reasonable, which I highlighted when you were introducing it, Tim. So that might have meant something to them at the time. Yes, they might have thought. But I suppose Lady Hale and the majority, and probably Lord Newburger as well, would agree. You can't dress up a discretionary power through clever drafting. It is a matter of substance, not form. So it's what the thing is in reality, rather than, smart, expensive lawyers all over this thinking that they've achieved an absolute right. If its nature is a discretionary power or fact-finding position, then, you can't get out of it. And I still don't think that's rewriting a deal. We've got lots of bits of law that on that basis rewrite deals.
Okay, so I agree with, so Tim, it's really interesting, that you are saying that is precisely preventing the party from acting purely for their self-interest. Because by approving the Saintier case, it is clear that whatever contractual discretion, and then we can talk about later what amounts to a contractual discretion, because the impact of this case has been severely diminished by the Mid-Essex case defining contractual discretion quite narrowly. So when a party has a contractual discretion, applying the Saintier case, they cannot do so, as Maggie said earlier, irrationally, capriciously. And so therefore that is where, indeed, Maggie, I agree with you, the implied term is important, that when they say they're going to do something in the contract on certain conditions, they need to make sure that indeed they are doing so. So the self-interest here is taken away. They cannot just on a whim, as you said, Maggie, decide that actually in this case, we don't think death in service benefits should be payable because, as Maggie said, we don't like the colour of your eyes. So indeed, here it is not a whim, and therefore I would say the self-interest here, they cannot do something solely because they feel like it. It has to have a basis in the contract, and that's where I agree with Maggie that the court do not interfere with a party's business, because the implied terms has to be necessary and following the usual manner in which the court imply a term in fact.
Another interesting point when you're talking about trying to avoid this effectively would be to sort of look at an express term, as I think you're suggesting, that tries to get around the end result of Braganza, and that's going to engage, certainly for a consumer, the Consumer Rights Act, isn't it? So something that is dressed up to appear to be an absolute right with no possibility of challenge, that's going to be a problem if you're dealing with a consumer. What's interesting, I think, is the Unfair Contract Terms Act. So between businesses, it's not very happily crafted, is it? If you look at the Unfair Contract Terms Act, it's not naturally going to fit with this very easily. Have a look at sections 3 and 13, for example, and kind of like say, well, does that really work here? I don't think those provisions were really drafted with this sort of thing in mind at all. So perhaps we need to look more broadly at the 1977 Act and ask ourselves, does that need an overhaul if people are really going to try and evade this by clever drafting, if you like. But as I said at the beginning, I doubt they will, because in practice, these hurdles are not difficult to overcome. So why make a problem for yourself by trying to craft an express term that may not work anyway, that public policy and or some statute says you can't do it? it's making more difficulty for yourself. Just try and meet the natural low hurdles, and you haven't got a problem.
Well, I wasn't thinking of the impact of this case in consumer case, actually, because in a way, so I go back to the parties' interference, even though we agree that, it's not so much interfering, it's applying the common sense interpretation, etc., etc. But still, there are some businesses which find that the fact that their contract are looked at in so many details by the court is just an interference to freedom of contract, etc., etc., and therefore it gives discretion. It's bad for certainty. But in here I was talking about because one of the things that the case does is that it adds good faith to the fact that to the Sokimer.
Yeah, but it doesn't, though, does it?
Well, I know. In practice, we don't
want any of that, Séverine, my love.
No. I don't want to go back into a good faith debate. But the fact that it does add good faith,
it doesn't. It doesn't.
Okay, let's not. It does. It does say.
We should add in here that we will have a podcast on good faith at some point.
Yeah. No, I was mentioning
one that breaks the podcast forever.
I know. I was mentioning it because it does, whether you like it or not, Maggie. It does say good faith in the judgment. But what I had more in mind whether that case can be used in between two commercial parties, and by the fact that in the Middlesex case, the Court of Appeal said a pure discretion. There is a distinction between a pure contractual discretion and a contractual discretion and a pure contractual right. And there is no interference on the court, or there is no play of good faith on exercising a pure contractual right. Many cases have since then decided that, for example, a right to terminate the contract is a pure contractual right. Therefore, there is.
Well, that's an absolute right, and the law does not mess with that, does it? So. Fine, yeah.
That's why what I was saying earlier is that the discussion as to whether this case is too much interference for the parties is severely limited in practice by the distinction between a pure contractual right. So a right to terminate the contract on certain condition, that is a pure contractual right, and therefore a party who has that pure contractual right will have that pure contractual right regardless of what the courts say.
So that would be the main point of probable practical argument in following cases. Is this an absolute right, an exercise of an absolute right, in which case I may do it on whim, I may do it for perverse reasons, I don't like the colour of your hair sort of reasons, or is it a discretionary or fact-finding decision?
Well, the courts have made clear that a pure contractual right is not interfered with the Braganza type implied term.
Yeah.
So what we haven't covered yet is, of course, Lord Neuberger's approach to this. And that does lead me to one of my questions, which maybe we can just hold in the background for the moment, is, and we were skirting around this, I think, earlier on, was the fact that it was Mr. Braganza here, or Mrs. Braganza, actually, whose probably livelihood depended on this case, whether the answer would have been any different if this had been a purely commercial party. Let's start with Séverine. Do you want to take Lord Neuberger's approach to the case, and then we'll have a look at that?
Yeah, I find Lord Neuberger, who dissents, nevertheless interesting because on if you look at the length of the decision, Lord Neuberger's dissent, takes about half of the case compared to the majority. And I think he really dissects the contract. He goes out of his way to show indeed whether the decision was right or not. But nevertheless, I think he has a lot of sympathy for the majority. And so I think that's why he goes into almost overdrive in, making clear that he disagrees. But nevertheless, at several points, he does I think agrees. So one of the points that he agrees with Lady Hale is the standard, so the scrutiny on both what Maggie described earlier as, and what I described as procedurally and substantively.
That's the interesting thing, though, isn't it, Séverine? He actually agrees with the majority on the legal test.
Yeah.
So actually, you could say this is unanimous in terms of the test. His problem is Lady Hale perhaps struggling to find that the decision maker has tiptoed beyond the four corners, and he would say actually they did keep within the four corners. This isn't what a court would have decided. This is what that person in that position ought to be having in mind when making his own decision, and we can't really challenge that on the facts.
I probably would agree with you on that, because indeed he just, he spends, between paragraph 107 and 127, he does go through every single point that the report has done in order for him to say that it was not reasonable. And so I think I probably would agree that he's got, so that's why I find his judgment so interesting, because he goes out of his way to say how he disagrees, but in effect on the legal bit, you're right, they are together. But I think therefore he dissects the process and the manner and what was taken into consideration. He does go a lot into saying that, certain things were not taken into consideration in order to decide whether the suicide was reasonable or not. And so again, that is interesting in itself. So yes, that I find, looking at the dissenting judgment here, that he reluctantly dissents, or he finds so many arguments, but yes, on the legal bit they agree. And so that's why, for you guys, for students all over, interesting to read the dissenting judgment as much as the majority.
But I don't mean to be disrespectful to Lord Neuberger, of course, but you know, a cynic might look at that and say, well, that's a very easy dissent. If you know that the outcome is going to be what in your heart morally you might want, you can make all the legal points that you want, but from a position of comfort, knowing actually it's not going to alter things.
Wow, I don't know.
That was
Lord Neuberger, he has retired.
Well, I don't mean that disrespectfully, but, if you know that you are the only one who takes a different view, there is a certain comfort, or I would say a freedom, in articulating your view. And he goes out of his way, as you say, he says you've got to have a very cold, stony heart not to feel for Mrs. Braganza, and he certainly did. But he's relieved of that ongoing grief, if you like, knowing that actually he's in the minority. What he says won't have affected Mrs. Braganza. I'm not a judge, but I could see that, you could sleep at night with that position, because you've made your legal position clear, and there's a sort of purity and beauty in that, is there not? As we're lawyers, we like to be right all the time. So, he's nailing it down. He's right in his view in law, and actually what he says is very powerful. He may well be right, if you like, if there is a single right answer. But he has the comfort of knowing I have not actually made any awful end result that I might be wrong about for this human being, Mrs. Braganza. But, judges are not supposed to, are they, be influenced by the individual circumstances of the parties, because that way leads madness, doesn't it? You've got the Supreme Court making binding precedent, binding on everyone in England and Wales, and all of the courts below. You can't do it on that basis. But, they're human beings. Judges are human beings. They can see the anguish and the difficulty of that family. But somehow, I don't know how they do it, somehow that has to not feed through into the decision-making process. And I suppose some people, if I'm playing devil's advocate, could look at the judgment of Lady Hale and say, actually, that looks like reasoning backwards. That is the end result she's trying to get for Mrs. Braganza. How legally do we fashion that? No, that's a contentious thing to say. So I'm not suggesting it that I believe that, but someone reading it might see it in those terms. Judges are not beyond criticism, like MPs are not beyond criticism. So there's some interesting things that we can look at whenever we look at any judgment to see actually what's going on here. Is it a pure science, as it were? Well, of course it's not. Law is not a pure science, and it's bound to be coloured by the human perspective. And how do we, judges are expert in their experience, expert in their knowledge, but at the bottom, they are still human beings. How much of that feeds through into the decision? It's very difficult. It's impossible to unpack, isn't it? So the only point I'm making, I'm not attacking Lord Neuberger. The only point I'm making is, I could see myself, if I was in the minority, there is a comfort. You're totally free in the way in which you are giving your judgment, you're doing your analysis, but actually there is a freedom in that. It's not going to have a practical effect on Mrs. Braganza. So I imagine that is some relief to him as a human being, and he is a human being. That's all I'm saying.
And I'm wondering actually on that. I mean, you say that we can't take that into account, but I'm not. To a certain extent, I think we can, because I mean the power imbalance between Mr. Braganza and BP is quite obvious, as it would be, for example, with a local authority applying measures and
yes,
and
but Tim, that is a power imbalance in terms of the decision-making process. And that for sure must mean, to come back to Séverine's argument at the beginning, that must mean that there is some restrictions on that decision-making process because, as you say rightly, there is this incredible imbalance. Who has all the information? The employer. Who has none of the information? Mrs. Braganza. That must mean, and that strengthens the test, as it were, or the need for the test. But I still say, it's a reasonably undemanding test, just to make sure that you've taken into account relevant matter and ignored irrelevant matter, and it's not completely off the wall, irrational whim.
Could there be an argument then that actually implying a term in law then to, for example, employment contracts, that the standard should actually be higher? Have we missed a standard? Are we at the wrong level here?
I suppose they could have done that. They could have taken the view that this is employer-employee, and, like they've done in the past with, for example, landlord and tenant. We will impose one as a matter of law. But as I said at the beginning, I think it's interesting that the judicial technique being imposed here is the classic one at the moment, which is kind of like top of the shopping list for most courts, is to look at this as a matter of construction in terms of working out what the bargain was of the particular parties. That seems to be, sort of the classic high point of that at the moment. Rather a sort of Victorian approach in a sense, that this is the bargain of the parties. This is the bargain of the parties. What does it actually mean?
Yes, in the context of that bargaining power.
Yes. And I guess that will apply across into other branches of contract which are not employer-employee. So the classic one of insurance, for example, Séverine, you were talking about two commercial entities. That would be, very common in the insurance setting. And yet there is still this gulf of expertise, gulf of information, gulf between them in terms of power and capability. Nevertheless, there's still two commercial entities. So, commercial entities are of an immense spectrum, aren't they?
Yes.
From the little guy who's probably not much different from Mr. Braganza in a commercial setting to an enormous PLC that is perhaps as strong, if not stronger, than some insurers.
But I think regardless of whether we are in a B2B contract or whether we are, so between two business or whether we are between a consumer and a business, I think it is reassuring that the same standard is going to apply, that if you have a contractual discretion, which is going to have an impact on the other party, you can the protection is that you have to take into consideration the circumstances in which you have the right to exercise that, and it cannot be on a pure whim. So if you consider this to be a low standard, I would say this is okay, but it's reassuring that regardless of whether you are a multinational, a consumer, or a sole trader.
Yeah, I agree with you. There's a purity in it, and certainly, as you were saying a few minutes ago, there is the ideal or objective of certainty and predictability. There is a neatness in it. And it's a reasonably manageable, understandable kind of test anyway. So, I can't see that there is any real problem with it. There is a beauty to it, I think.
So what do we think? Correctly decided then is the verdict?
Yes.
Yeah. And actually, whether you're minority, Lord Newburger, or whether you're majority, Lady Hale, I think they're both right. Is it possible to say that?
That's a wonderful way to end. Everybody is right and everyone gets a medal.
Well, we all want to be right as many times as we can, don't we? I don't think it's just lawyers, but I think we are peculiar in that sense.
I think we should add that to the purpose of the podcast. Our main aim is to be right.
Yeah.
And with that, I think we can wrap up for today. Thank you very much to Séverine, Maggie, for joining me here, and we'll have another topic in 2 weeks. Thank you very much for listening, and
thank you very much.
Thank you. Enjoyed it a lot. Bye.
Bye.